All right, looks like we're just at the hour here, so why don't we get started? We've got a lot to discuss today. My name is Joseph Caniglio, and I am the Director of Antitrust Innovation Policy and the Schumpeter Project on Competition Policy here at the Information Technology and Innovation Foundation. On behalf of ITIF, I want to welcome you all to this really great panel we have, DOJ v. Google, the Remedies decision, and the future of search. So as brief background, DOJ v. Google search represents a very long-running antitrust case, first brought by the Trump administration, litigated in court by the Biden administration right here in DC, and following a liability decision, finding that Google had a monopoly in search and that its agreements with various browsers, Android OEMs, and wireless carriers to make its search engine the default at a variety of access points anti-competitively maintain that monopoly. A second Trump administration litigated a remedies trial, resulting in the decision issued earlier this month by Judge Mehta, which we are here to discuss today. So at bottom, there were three parts of Judge Mehta's remedies decision. First, Google will be forbidden from entering into exclusionary agreements to pay for default search placement for search and also actually for several other products, although it will be allowed to make non-exclusionary payments for default search placement, including to Apple. Second, Google will not be broken up, i.e. it won't be forced to divest Chrome or alternatively its Android operating system, although it will be subject to other limitations on its behavior, basically designed to eliminate the anti-competitive effects its conduct cause, such as restrictions that prevent it from engaging in certain types of tying. Third, while Judge Mehta rejected the DOJ's desire to ban Google from unilateral self-preferencing, on the grounds that it was too speculative and that this practice would be basically too speculative that it would be anti-competitive in the future, he did impose a series of syndication and data sharing remedies, with the latter expressly designed as a way to supposedly eliminate the fruits of Google's ill-gotten gains. So to discuss the merits of Judge Mehta's decision and what it means, I'm fortunate to have with me really a great, excellent group of experts. First, Kathleen Bradish, Vice President and Director of Legal Advocacy at the American Antitrust Institute. Prior to AAI, Kathleen served in government, including as Assistant Chief and International Counsel at the U.S. Department of Justice Antitrust Division, in addition to having a distinguished career in private practice at Cleary Gottlieb here in D.C. Kathleen, welcome back to ITIF. Second, Diana Moss, Vice President and Director of Competition Policy at the Progressive Policy Institute. Prior to joining PPI, Diana was longtime president of the American Antitrust Institute and also served as an economist at the Federal Energy Regulatory Commission. She has spoken and published widely in all areas of antitrust and competition policy and is also an adjunct faculty in the Department of Economics at the University of Colorado at Boulder. A pleasure to have you back with us, Diana. Third, Herb Hovenkamp, the James G. Dinan University professor at the University of Pennsylvania Carey Law School. Needless to say, Herb's contributions to antitrust law can't be done justice here. So I'll just say Herb is the leading scholar of U.S. antitrust law, the dean of the antitrust bar, in the words of the New York Times, and his vast corpus includes hundreds of articles, over 1,000 citations by federal courts, and dozens from the Supreme Court alone. He's also co-author of the magisterial Arita Hovenkamp Antitrust Treatise, which I should add was also cited by my count close to 30 times in Judge Mehta's remedies opinion. So Herb, it's a privilege to have you back with us.
Thank you.
Finally, Brian Scarpelli, Senior Global Policy Counsel at ACT, the App Association, a global trade association representing more than 5,000 app makers and software companies in the mobile economy, as well as Executive Director at the Connected Health Initiative. Prior to joining ACT, Brian was Director of Government Affairs at the Telecommunications Industry Association, and before that worked at the DC Public Service Commission, our public utility right here in Washington, DC, in addition to being a great golfer, at least relative to yours truly, which isn't saying much. Brian, welcome. Great. So why don't we just jump right into it and start with the breakup question. And Herb, I'll let you start us off. So obviously a big part of what the DOJ had sought, consistent with a lot of the populist rhetoric we've seen from the neo-Brandeisians over the years, was to try and break up big tech. And as Judge Mehta concluded, that those remedies, specifically divesting Chrome and Android, were not justified based on the legal standard that he applied. So what's your take up on the breakup issue? And did Judge Mehta apply the right standard?
Uh, well, yeah, my answer to that last question is yes, I think he did. Breakups were considered the preferred remedy in Section 2 cases until, the 1940s and 50s, when decisions like National Lead and Timken Roller Bearing, a little bit later, United Shoe Machinery, all declined breakups uh, in, uh, in such cases and began looking for more modest relief, largely, I think, in response to a fair number of failures, situations where markets simply did not become more competitive as a result of the breakup, and some in which firms were even driven into bankruptcy because of breakups. Uh, that's one point. The other point is that the unusual thing about the particular breakups that were requested in the Google case did not actually break up the monopoly. The search monopoly consists of mainly a very large database of web pages that Google has aggregated. It is by far the largest among search engines, 2.5 times as big as the Bing database. But the divestiture of Chrome wouldn't touch that. It couldn't. There's really no practical way to break up a search engine. Rather, the theory behind breaking off Chrome was that Chrome was kind of the lever that Google was using to facilitate the creation of its monopoly. And Judge Mehta found that not to be supported by the record. In fact, he concluded really that the principal thing that Chrome contributed was that it made Google Search its own default search engine, but that was no different than Apple and other large implementers. And as a result, the causation standard for a breakup simply had not been established.
Herb, thank you. Very helpful to start us off. Kathleen, I want to turn it over to you. And Herb mentioned the causation issue. I know this is something you have a great paper out on that I would commend to our viewers. So I think Judge Mehta treated basically a but-for causation test as sort of a threshold requirement for whether a breakup could be justified. And that's, of course, the standard he got from the Microsoft case. So how should we think about that? Was that too strict an approach to causation from your perspective?
Well, I would say as an initial matter, I don't disagree with Herb on the legal standard here, but I would disagree with the characterization that there is any implication of a but-for causation standard in this opinion. I think at the very outset of discussion of the remedy, Judge Mehta goes through Google's arguments on but-for causation, that the plaintiffs would have to show that but for the monopoly or but for the conduct, Google would not have a monopoly position or would not have maintained its monopoly position. That was the position Google took at the outset. And the Judge Mehta did a pretty thorough debunking of that argument, pointing out that there's never a situation, and rarely ever a situation, in which you would have a monopoly that exists only because of the illegal conduct. So I think he did a very thorough debunking of a lot of the arguments Google made on that account, including close readings of the Microsoft case and the lower district court opinions on the remedy itself. Instead, what I think you see in Judge Mehta's opinion is a strong vindication of the lower court's discretion to craft a remedy on the basis of the facts in front of it, and a strong viewpoint that there should be a sliding scale, that proportionality is an important, essential element of any remedy that a judge puts into place, and that your causation standard, the more severe the remedy, the stricter the causation you might look for under Microsoft versus a less severe remedy, you might not be so demanding. I don't necessarily agree with that particular formulation of the proportionality, but I think it's important to point out that it is a sliding scale, and he rejects any, and I think what he's very right to do is to reject any particular notion that you would have to have one particular kind of case in order to have a divestiture, like it would have to be an asset acquisition in order for there to be a divestiture, or that you would need the Microsoft or the significant causal connection for anything other than a bare bones kind of cease and desist, stop the illegal conduct type of remedy. So in short, I think he makes this a very factual based opinion. It's a very open standard as far as I can tell, and I think it rejects any one-to-one, any prescriptions on certain types of remedies, and I think that in essence leaves a lot open for other judges, for both on appeal and for other cases that might be in the works.
Thank you, Kathleen. Diana, turning to you, we've talked about this heightened causation standard that heightened standard that Judge Mehta applied to evaluate structural relief. Herb touched on sort of how the breakup was not really narrowly tailored to the conduct found at issue. Kathleen discussed causation, but there was also this discussion about whether it was sort of the least restrictive alternative, right? Whether behavioral remedies were sufficient to deal with this type of conduct. Do you have any thoughts on that, or the structural question more generally?
Yeah, thanks, Joe, and appreciate being part of this important conversation. I think there's a lot of legal and economic value added here in Judge Mehta's opinion. He starts out by with sort of the building blocks, the basic principles that, a remedy has to restore competition, the remedy has to have a nexus with the competitive harm, and it has to be forward-looking to prevent future anti-competitive conduct. And within that framework, of course, comes the causation, which is the nexus or the connection to the competitive harm. And I actually like the sliding scale approach. I think it makes infinite sense in the context of the markets involved here. Digital markets in particular, markets that are integrated in complex ways across a digital business ecosystem. So I think that resonates against the economic backdrop of what we're dealing with in this particular monopolization case. So, the readout is, the more drastic the remedy, the more severe the remedy, the greater the connection, the causal connection must be to support it. And I think that's spot on. DOJ took a very different approach, an approach we might have seen more in a vertically integrated manufacturing entity, covering markets for inputs and distribution, retail distribution. That's not what we're dealing with in a digital ecosystem. We're dealing with far more complexity, far more economic anomalies like network effects, data externalities, that sort of thing. So I think it fits well with the problem at hand. I also think that, for example, with the declining to force Google to divest Chrome, that sort of brings up an interesting thought, which is, we're so used to thinking about divestitures in the Section 7 context for mergers. And that is, of course, very different than a Section 2 context, right? Where the bad conduct has already occurred versus Section 7, where we are trying to prevent a harmful merger before it happens. That's the incipiency standard. So in vertical mergers, we're thinking more about, traditional foreclosure theories in vertical context about how divestitures would reduce or eliminate incentives. That's really not the case in a Section 2. There has to be a strong showing that a divestiture would absolutely be necessary to prevent the anti-competitive conduct with a very, very close nexus and into the future. And I think that just wasn't present here. So, bottom line, I think the sliding scale sort of proportionality causation approach works.
Diana, thank you. Brian, turning over to you, I want to pick up on something Diana said. In addition to the causation issues we've discussed, whether this is a tailored remedy and, again, whether it was even necessary, Judge Mehta also talked about whether this remedy being unnatural, right? That it would be very practical, very risky, and a lot of the synergies that make Chrome what it is would be lost. So what are your thoughts on a breakup and maybe particularly those practical consequences that Judge Mehta considered?
Yeah, thank you very much. And thanks for having me here, by the way. Appreciate that. To give everybody, I know Joe gave a little bit of perspective on sort of where we were coming from in our tracking and even weighing in as amici in this case. But, it's a very broad, diverse range of developers, all have in common that they're micro, small, or medium-sized. The rise of this segment that my association represents, you could say, directly correlates to the rise of some of these tools and markets that are at issue here. So there's a very, we generally, I think, were of the view that Judge Mehta was careful to reject wide-ranging remedies that weren't really directly linked to the findings. And that reflects a commitment to this principle that we certainly share this view that antitrust relief should restore competition. And there was even some calls for less restoring competition and more punishment or fundamentally re-engineering markets. And what ultimately a community like ours is weighing in to do is to make our voice heard and assure that the parts of these markets that work that are responsible for that empowerment and opportunity and job creation that 95% of the developer community, frankly, effectively, that we represent, isn't, that we're not fixing something that isn't broken. We were particularly we were particularly vocal about the proposed Chrome divestiture. We thought that the forced structural separation would fragment the existing ecosystems and impose some compliance and technical burdens. The well-integrated browsers and app stores, that minimize overhead and ensure reach to the broadest possible base of consumers to establish and maintain trust is the ultimate practical point that I think we were trying to raise, and it does seem that that where this remedy decision ended up has kept that in mind.
Brian, thank you. I kind of want to move to the next topic and pick up again right where you left off on this idea of broader ecosystem-wide effects that Judge Mehta considered when looking at these remedies. And, in addition to the breakups, a big part of this decision, I would say even really the major part, was preventing Google, stopping Google from engaging in a number of practices, primarily these exclusive agreements, search distribution agreements, default search distribution agreements with Android OEMs, browsers, and wireless wireless carriers. But of course, what was exempted from that was allowing Google to still make non-exclusive payments, within a year to Apple and others. And a big part of that had to do with, as Judge Mehta noted, the risks and harms that might occur to other parties like OEMs, carriers, browsers, developers. So Kathleen, why don't we start off with you here? What's your view on that particular question, allowing Google maybe to continue to make payments that are on a non-exclusive structure to those parties, and maybe other prohibitory injunctions that Judge Mehta analyzed?
Yeah, so I think there are two parts to that. The first being, was it okay? Was it right for the judge to continue to allow certain payments? And the second being, was the scope of the prohibition accurate? So I'll start with the first. So with respect to the payments to Apple, I think this is a place where maybe Judge Mehta's judicial humility got the best of him. I understand part of what he is saying with respect to both some of the payments and some of the other contractual arrangements. He was concerned about the effect of ending everything, that ending these relationships or interfering with these relationships and what the effect might be on consumer welfare. So I understand that he was hesitant about that. However, the truth of the matter is that this is the key illegal conduct that was found to have been engaged in by Google using exclusionary contracts and exclusionary, de facto exclusionary contracts that essentially made Google the exclusive default. So I think there is danger, and I think Judge Mehta recognizes that, because he does preserve the right to come back and look at this again if it does not work out the way that he anticipates. There's danger in allowing these arrangements to exist in similar forms. So that's, I think, especially one of the things I don't think Judge Mehta takes into account and needs to be taken into account in remedy discussions is, what do we know about the defendant and its ability to get around constraints placed on it by the court, its history of compliance, and what its incentives, ongoing incentives are. And all of those point to the fact that Google will be incentivized to try to get around these existing restrictions in the remedy. And in fact, we begin to see that now in some of the briefing that's come after that, after the decision, the briefing by Google and by DOJ in the States on how this remedy will actually look. And we see that Google is choosing to interpret the judge's wording extremely narrowly. In fact, it's saying exclusivity is fine as long as it's not a contract, if it's unilaterally imposed exclusivity. So all that is to say, I'm not sure that the allowing discretion or allowing certain payments and certain arrangements to continue out of a concern for consumer welfare takes into account fully the extent to which the defendant still has an incentive to try to get around the restrictions the court is putting in place. And I think that, just briefly, I think that brings in the point on, why did the remedy go beyond search in some cases? It also included Gemini and Chrome and Google Assistant, for example. And all of that is of the same piece. The court is required to be forward-looking by Supreme Court precedent in terms of its relief. It needs to anticipate where the monopolist will go, given the incentive that's already been proved in the liability stage. And in this particular case, the Chrome and Assistant and Gemini were all part of what the judge, based on the facts, saw as potential future paths for similar exclusionary conduct, and that it was well within his right under Supreme Court precedent to say these are acts which are of the same type or class as the unlawful acts which the court has been found to be committed. This is from Zenith, the Supreme Court Zenith case, or maybe fairly anticipated from the defendant's conduct in the past. So he was right in this, in my view, to anticipate it by extending the prohibitions beyond search itself into some other areas that are nascent competitors to search. But he may not have gone far enough in anticipating the defendant's ability and incentive to get around the restrictions by allowing some of the relationships to continue.
Kathleen, thank you. Diana, turning over to you, your views on the prohibitory injunctions that Judge Mehta implemented and did not implement, and maybe especially this question about Google's ability to still make payments for search. I mean, clearly on the one hand, banning a company from engaging exclusive dealing doesn't prevent them from dealing their product and trying to still win business, right, on the merits. So how do we thread that needle?
Yeah, I think I'm not going to say it's a difficult needle to thread, but it certainly is a challenge. And I think this case sort of sets the mark on threading that needle in future monopolization cases involving digital markets and digital ecosystems in particular. But look, I think injunctive relief, which the Judge Mehta himself would consider the least restrictive on this sort of sliding scale or spectrum of linking remedy to causation. In this case, it goes a long way. That was a primary method by which Google was alleged to have maintained its monopoly, and the DOJ won on liability. But Judge Mehta himself admits up front, like in the second page, that he approaches this with great humility, that we have a new technology lurking out there called Gen AI that is really disrupting and changing how these markets work. So I think the whole opinion is sort of constructed around this approach that we have a traditional search, but it is being rapidly challenged by generative AI technologies. It's not being displaced, but it is being challenged by, meaning I don't see full-scale displacement coming up, but what I do see is the introduction of generative AI technologies as complements to traditional search. And that's really how that's really shot through all the arguments that Judge Mehta makes. It also goes hand in hand with his repeated recognition of the impact of the remedies on consumer welfare. That's something that it just wasn't in the DOJ's proposed revised final judgment. I think I counted consumer welfare one time in that entire document. And that was the basis of the piece that I wrote last spring, saying these remedies are really not cognizant of their impact on consumer welfare. And that's who we're trying to protect. We're trying to protect consumers here. And so I think that's a reason why he didn't go as far as to require divestitures, either of Chrome or a contingent divestiture of Android. But the major theme is, look, we've got to prevent exclusive contracts and anything involving conditioning, revenue share, preloading of search or Chrome or Google Assistant or Gemini. We have to prevent that because it was a major way that Google was able to maintain its monopoly. But by preventing those, we're actually opening up the market to competition, and we're enabling rivals to be able to participate in the market as viable competitors or near viable competitors. So it was all about spurring competition. And so spotlighting Google Assistant, for example, and Gemini was really part and parcel of recognizing the introduction of new technologies, the importance of allowing rivals to avail themselves, to scale up, to use new technology. So they had to be included in the injunctive relief part of the order. And finally, I think on the judge declining to ban revenue share, that has a really, really good economic grounding, which is in these complex digital ecosystems where we have multiple complementarities between markets, and those are complex complementarities. That's the value proposition. The value proposition in it isn't, oh, I'm working in a silo, I'm competing in a silo. The value proposition is, how can I partner with other entities in this ecosystem to create or enhance my value proposition? If you prevent economic incentives to engage in collaborations, then you will effectively kill off or limit competition in those adjacent markets or those complementary markets. I think Judge Mehta was very cognizant of that when he said he was not going to require a stop to revenue sharing.
Diana, thank you. Herb, turning it over to you now. Want to get your thoughts on this issue, and also maybe specifically, we've heard Kathleen and Diana mention this idea of prohibiting similar practices as part of, sort of standard fare among prohibitory injunctions. I mean, what are the limits to that, though? I mean, to what extent can you include products separate or even different practices like conditioning, right, that really aren't the same as exclusive dealing? So did the court get that right in your view?
Yeah, I think its basic statement was right. You clearly can go beyond those things found to be unlawful if the remedy demands that. That's one side of the coin. The other side of the coin, which I think has caused more consternation among people, is the extent to which the remedy appears to permit conduct that the liability decision found to be unlawful. And of course, we have a template for that. In the main liability decision in Microsoft, the 2001 decision, the court found that commingling of the internet browser code into the Windows operating system code was illegal. And however, then fast forward 2 years, we get a remedy in which Microsoft was permitted to maintain the browser code in the operating system code. However, OEMs were permitted to remove the icon, and of course, users were permitted to install as many additional browsers as they wanted to. And I think it all speaks very strongly in support of the DC Circuit's ruling, the really decisive ruling where it rejected Judge Jackson's opinion below, that we need to have a separate investigation and hearing with respect to the remedy. Because just as in the Microsoft case, a lot of water kept flowing under that bridge after the liability decision occurred. In this particular case, it takes the form of generative AI, but things were changing very quickly. And as a result, the remedy needs to look at those subsequent developments as best it can. Of course, it didn't have any fact findings about where AI is going to land, and we still don't know that. But I think the court got that about right. The other thing is there's been a tendency, particularly in the part of the press, to look at these payments almost as if they're per se illegal market divisions or something like that, more like cartel payments. They really weren't. They were really co-investment payments. I think Diana just made this point. There was a great deal of co-investment going on. Some of the implementers, like Mozilla, were heavily reliant on these payments simply in order to survive. And so there was a lot of pretty delicate issues that had to be managed here. So I do believe, however, one qualifier here, I believe that of all of the things that are likely to provoke ongoing review in this case, the issue of payments is probably the most prominent one. Have those payments been metered accurately? Is Google interpreting them, its ability to continue making them too broadly? I think one big issue that still lurks is to what extent will these payments act as an inducement to other firms such as Apple to refrain from developing their own search engines? Those are all unanswered questions and things that we're more likely to have answers for a year or two from now. And just finally, just as a reminder, go back and look at what happened in the United Shoe Machinery case, where the 1954 merits decision, Judge Wazansky refused a breakup of United Shoe Machinery. He imposed a number of conditions on leasing as opposed to selling, on lease rates, price discrimination, some other things, but then retained jurisdiction. And 14 years later, 1968, the Supreme Court finally looked back at it and decided that USM's compliance had not been convincing enough. And then it went ahead and did order what proved to be a disastrous breakup of United Shoe Machinery. But there's plenty of precedents for reviewing and doing second and third looks at these kinds of issues.
Herb, thank you. I think it's a great point to remember, just as the court has discretion to go after similar practices that it feels are necessary to restore competition, it also has discretion, as was you discussed in the Microsoft case, not to impose remedies, even if they're very close to the conduct found to be anti-competitive, if they're going to have negative consumer welfare effects. And I think that's definitely a good point Judge Mehta made with respect to an outright payment ban. But Brian, next, your thoughts on the question of prohibitory injunctions, please.
Thanks. Yeah, just kind of rounding up and building on what everyone else has said, and you won't find me strongly disagreeing with much of what you've heard right now. Just but from where we're where I'm sitting, we're that just generally our community's fear was overly broad injunctions would limit some pro-competitive aspects of the market here, and it does seem that Judge Mehta generally heard that concern, and that the decision reflects that concern. For the smaller players that we work with all the time, who they have business models that depend on distribution deals and predictability and revenue flows, and we were worried about some kind of overly blunt or disproportionate remedy that would ultimately harm our community, and don't see I suppose you could say everything's relative. But we're relieved, I suppose you could say, with how things have shaken out so far. But I would just kind of violently agree, especially with what Herb was just saying, that that continued monitoring is going to be important, and how this shakes out on appeal, both for the decision on liability, but also on remedies, is going to be super important.
Brian, thank you. Moving over to our third topic, and I just want to also remind our audience, please do submit questions if you have them. We always have such great conversations, so we got to, the time always is of the essence. But moving now to the third bucket of remedies that we discussed, sort of affirmative obligations, forcing Google to share data, syndication. Diana, looking at you to start us off here, I mean, I think it's pretty clear that if we're talking about sort of remedies beyond just the conduct that was found to be anti-competitive, clearly there was this proportionality analysis that you and others have mentioned. On the one hand, you've got structural relief, a very high standard applies. And then for some of these other prohibitory injunctions, of lower standard, is it reasonably capable, for example, of stopping anti-competitive effects? And it seems like, well, let me just say, what should have been the standard to evaluate these data and syndication remedies from a proportionality analysis?
Yeah, that's a good question. I guess I view the data requirements, the data sharing requirements, as a necessary requirement. I'm just trying to put myself into Judge Mehta's head for the reason that it not only ties to the anti-competitive conduct, so there is a nexus, but that nexus is supported or even amplified by the fact that the judge very early on and clearly recognized that data is the value, it's the currency in a digital ecosystem, right? It's a direct feed into the value proposition, which is to amass enormous amounts of data from users. User data is important, but also search data in this case. And to harness the value of that data to and monetize it through advertising. So I think Judge Mehta sort of keyed in, really honed in on the value proposition in this particular case. And by the way, this will be the case in other digital monopolization cases when we're talking about ecosystems where data is really the currency. And so that's where he went, and that's what I think necessitated a very limited, narrowed scope of what data Google would be forced to share, and that was search index and user interaction data. And here again, his overarching goal, and he made this really clear, was that getting access to data was essential for rivals to be able to compete. And when I say compete, I mean things like scaling up, producing high quality search results, right? Gaining distribution, making your product, your new search engine or access point attractive to consumers in the market. Here again is the consumer welfare component. Most importantly, I think Judge Mehta's goal here was to find the smallest possible set of data that Google would be forced to share with potential rivals, meaning qualified competitors that this technical committee will decide the merits of, and really put the pressure on rivals to innovate quickly. It's all over the opinion. He wants this to happen fast, and he wants a narrowly construed or tailored remedy to force rivals to innovate fast, to scale up fast, to produce high quality products and services, to differentiate themselves. So all of these sort of economic concepts are at the core of why he required this remedy, which again, very tied to the competitive harm, and very much part of this proportionality sliding scale approach. But with that said, he was very concerned about overreach by DOJ, for example. DOJ wanted lots of data, data gathered from partnerships, from data feeds, stuff that sort of strayed away from the core or the nugget of what was the value proposition in Google's search business. So he limited the data that had to be produced, limited it, for example, to websites that were website information that was crawled. And they only got a one-time, rivals only get a one-time snapshot. They don't get repeated periodic dumps of data. Again, encouraging fast, almost forced innovation, but most importantly, not punishing Google for the engineering and the innovation that they put into the development of the search engine. Now, on the user side, the user data side, again, DOJ wanted metadata. They wanted lots of data. They wanted click and query data, which absolutely raised privacy concerns, which PPI raised in a white paper earlier in the year. They wanted data to help build, operate, and train models. And so Judge Mehta scaled back on that for the reason that there were privacy concerns, right? So he capped the amount of data that could be released, and recognized that the burdens of anonymizing this user side data would pose issues. And he also left that window open as well to revisitation at some point down the road. So I think this was sort of the approach that the judge took, in terms of recognizing the value of data, putting a lot of pressure on rivals to get access to limited amounts of data so that they could innovate very quickly and scale up, and become viable competitors in the search market. If that actually serves that purpose and that's what happens, then I think this particular remedy would be pointed to in future cases as an example of a more successful affirmative obligation.
Brian, turning to you next, your take on the data sharing, syndication, affirmative obligation remedies, and maybe also touch on that privacy point. I mean, I think it's true. That was certainly a big argument Google raised, and something Judge Mehta tried to grapple with, and tailor the remedy accordingly. Did he get it right?
On net, I think we're heartened by this particular aspect. Just our view generally, forced data sharing mandates should be pretty narrowly tailored to avoid exposing user privacy to unacceptable risks and undermining consumer trust. And that's really the foundation that drove, I think, a lot of our community's concerns is that, back to my, I think, earlier comment about not fixing the parts of the system that aren't broken, is that, there's an incredible means that exists in, today's digital ecosystem for for reaching and gaining and maintaining new customers for small and nimble organizations like micro, small, and medium-sized entities like the ones that we represent. And so Judge Mehta's acknowledgement of privacy risks in his ruling is consistent with what we raised in our own filings with as Miki. And we were generally encouraged by that, again, based on that rather existential issue to us, user trust.
Brian, thank you. Herb, turning to you next, want to get your thoughts on the data sharing, syndication remedies, and maybe you mentioned the Massachusetts v. Microsoft case. I mean, we also have some good language there on remedies that involve the fruits of a violation. And specifically there, the court sort of rejecting some remedies that were sort of premised on Microsoft undoing ill-gotten gains or divesting the fruits, and seemed to apply a little bit heightened scrutiny to that sort of a rationale. So what's your thinking on the data sharing issue?
Well, I think my most far-reaching take is that compulsory licensing, such as was ordered in this case, really is the structural relief for digital markets. That is one characteristic of purely digital markets, whether it be operating system, a social network like Facebook or X, or search engine, is they cannot be divided, not without causing very significant harm. I mean, you can't break up Facebook by, putting boys on one piece and girls on the other one, or making one part work in the northern hemisphere and the other one in the southern hemisphere. There is no way to break up Facebook. That's true of operating systems. We don't break them up. What we do is we share them, more like Android than a physical breakup where you cut the farm into 5 or 6 pieces and you give each person a chunk of it. So I think this is a form of structural relief unique to digital products. What you're going to get in the optimistic story is some group of qualified competitors. We don't know how many yet, but let's say 5 or 6 that are able to offer search engines that look a little more in performance like Google search looks. So I think that's a very promising development when we think about remedies in digital markets. I also think that Judge Mehta was correct, and to answer your question about some of the things in Microsoft, is that the number of transferees has to be limited. That was a mistake that was made in the initial AT&T remedy. Judge Harold Green's remedy in the AT&T case, where interconnection was global. And then we went through a period in which, people were operating long distance service out of their garages with a minimum investment because they were able to hook in, buy some long distance time, and then repackage it and sell it. I don't think we want to create that kind of last mile competition. We want to have facilities-based competition where each of the participants, relatively few in number, are going to make major infrastructure investments of their own. So, there's a lot of guesswork, a lot of prediction involved in the remedy Judge Mehta came up with, but I think he landed on the right initial place. Is it possible that 5 years from now, court would decide that more sharing or something is necessary? Sure it is. But I think as a starting point, as Diana pointed out a few minutes ago, a narrow sharing obligation, a one-time snapshot of the data to be transferred is about the right place to get this going. And if they pick the right set of transferees who are motivated to make this investment and who have the resources to do it, I think we could get a much more competitive search market.
Thank you, Herb. I mean, it really raises the question. I mean, if it is basically de facto structural relief, I mean, based on the proportionality analysis, should a heightened standard applied? But Kathleen, maybe throw that question at you, and also, also note, of course, there were some affirmative obligations that Judge Mehta rejected, specifically choice screens. So, and any thoughts on that as well?
Sure. So I think with respect to the data sharing obligations, as an initial matter, I think it was very clearly, he wrote quite well about how the data was the fruit of the illegal monopoly, that this was part of what Google was able to get the flywheel, the network effects, that the additional data, the data that they got as a result of directly as a result of their exclusive contracts, became the material form, making themselves, raising the entry barriers for others. So it goes to the heart of the conduct that that Google was deemed to have engaged in, the illegal conduct that it was deemed to engage in. So it's hard to see an effective remedy that doesn't address that. Which brings me to the point that, I think sometimes what gets lost in some of these discussions about the Google remedy in this case is the question of effectiveness and the primacy of effectiveness, both as an initial matter under Supreme Court directives, under the purposes of the antitrust laws, that the remedy itself has to be an effective one. Herb discussed earlier, that this could be open to appeal on the question of the payments, because it's allowing some illegal conduct to happen. And I would submit that what the Supreme Court tells us on that is, in fact, that's the question that the appeals courts can address, is whether enough has been done to be effective. In particular, one can look at the Glaxo case, the Supreme Court Glaxo case, where the court said specifically, we don't review a remedy just under an abuse of discretion standard. We actually have an obligation to intervene in this phase of the case to ensure that the relief will be effective. So I mentioned that just to come back to the data sharing point, that data sharing is very easy to game. Again, I would direct people to look at some of the briefing that the parties have submitted on how the data sharing will be implemented. And we can already see that there's a lot of stuff there where Google is interpreting it extremely narrowly, who can get the material, and wants a lot of discretion of its own to decide who gets it and who doesn't. And, given the incentives we've seen already demonstrated throughout this case, I think you can already see in the way that Google's looking to interpret it, how easy it would be for them to game the situation, to share only under terms that are that benefit it, that make it virtually ineffective. You see the DOJ and the states have described why some of the restrictions that Google would like to place on these data sharing and syndication remedies would make them virtually ineffective. So I think that's a deep concern. And, it stands beside, you want narrowly tailored data sharing, but you also want data sharing that can't be gamed, and is actually effective and can't be undermined by the incentives of the defendant to render it useless.
Could I add one?
Kathleen, Brian, please, quickly.
Yeah, sure. Real quick. I just thought, especially in what kind of prompted me originally to want to chime in and just add on to this is the choice screens question that you had asked. But I just think there's a broader priority for us in this case and other cases is setting up requirements that are effectively a regulatory design exercise or micromanaging of a user interface is kind of like another concern to balance. And I think a reason I'd raise it in respect to choice screens is I think that that was seen by Judge Mehta there, but just that resonate that as a concern is something that I'd also throw out there, should always be kept in mind. Thanks.
No, Brian, thank you. I mean, in addition to the Glaxo precedent, of course, there's plenty of Supreme Court precedent and other cases talking about the risks of micromanagement, antitrust relief becoming basically regulation. And I think you do run into that risk with the data sharing remedy in particular. But I see we've got about 5 minutes left. So I think I would ask everybody, and we can just maybe start with you, Brian, any quick implications? I mean, what's the big takeaway from this case? There's a lot of appeals still to come, but I think there are some lessons we can glean from the decision so far. So, Brian, start us off.
Yeah, I think, and I'd be very curious on some of the other panelists, maybe if they have a view on this, because I end up spending a lot of time in like policy discussions related to these kind of things and these kind of decisions. That is, and to me, I think this decision it demonstrates that the U.S.'s existing antitrust laws provide a pretty solid framework that enable a reasonable and practical conclusion to be led at the end of the day, which has a lot wider implications for all of us. And will this decision prompt, advocates for new antitrust laws that I kind of view as taking a shortcut on these analyses that are so critical to reaching practical and reasonable decisions? I'm sure it will add fuel to the fire for some of those people, but for me, I'm heartened that generally this ended up in a reasonable place. Appeals are pending, as you mentioned, but for this remedies phase, we're quite relieved, our community. So I don't know if anyone else has any other views on that. I should stop.
Ryan, thank you. No, Herb, want to get your views, big takeaways on the case.
The elephant in the room in this case is generative AI. Clearly, Judge Mehta was blown away by how little attention had been placed on it during the pretrial phase all the way through the liability finding, and how much had changed in just a very small amount of time afterwards. He talked about the radical repositioning, the incorporation of AI into search engines, firms like Grok that had gone from 0 to top 10 out of 40 or so in just a few months' time. And I think that says a lot to a judge trying to devise a remedy, which is you want to be pretty cautious and you want to let the market work itself out. And I think that guided this decision. That's why I like it so much, is it's going to remove the more serious restraints, we hope, but ultimately these are decisions that are going to land where the market takes them, not where the court forces them to go.
Herb, thank you. Kathleen, want to turn to you next. Big takeaways. I mean, certainly from antitrust progressives, breaking up big tech has really been the goal. We've now got a decision suggesting what the standard is. Is this, for all intents and purposes, the end of the neo-Brandeisian breakup big tech movement?
I would say not at all necessarily. I think on legal standard, this is a pretty open legal standard that's articulated. It's very much about the facts of the case. So it gives a lot of discretion to a judge to figure out what's going on in a particular market, what's necessary to remedy the particular conduct in front of it. And I think Judge Mehta is very clear about preserving that and accurate in the context of the DC Circuit precedent that he's following. But on the other hand, I think this is a test of what the market will do. I mean, to the extent that AI is a disruptive force, will not being future looking enough mean that we're just enabling the same conduct to happen, the same kind of monopolization in the AI space that we saw in the search space. So I think this is going to be a real test. I think even just figuring out the details of this consent decree, or not consent decree, the details of this judgment will tell us a lot about the ability for these to really, this kind of a remedy, this kind of very specific remedy to police Google's behavior. So I guess I think the proof is in the pudding. We have to see how this gets implemented, whether the extent to which there's ways we can work around, Google will find ways to work around the remedy. I think it'll be a lesson.
Devil's in the details, as they say. Diana, last word is yours.
Sure, just three major points. First, I think this decision is a vindication of the consumer welfare standard. We did not see consumer welfare or even consumers referenced really at all in the initial, the revised final judgment. Judge Mehta brings it back to consumers multiple times and on multiple levels. His concern is the impact of the violation. There is absolutely a finding of liability, and we should all recognize that as a major development in a Section 2 world, especially in digital markets. And we now have remedies that address those specific violations, remedies that are designed to restore competition, that are tied to the harm, and that are forward-looking. So vindication of the consumer welfare standard, and I mean a broad interpretation. We're not necessarily talking about prices here. We're talking about use of data, data privacy, data security. We're talking about the ability of rivals to enter markets, to innovate, to be able to scale up, to produce high quality alternatives. So we're looking at a very expansive, accurate view of the consumer welfare standard. So I think that's important. And then second, look, we had sort of the battle of two very, very different remedial proposals here. One that was really fixated on looking at Google as more of a traditional integrated manufacturing enterprise and proposing a massive restructuring through spinoffs and quasi-regulation of the search platform that would have required huge amounts of involvement by the courts, who are not good regulators, by the way. I used to be a federal regulator. That's all we did 24/7 was regulate. We saw that in very stark contrast to what the judge has come up with in his opinion. And so I think that will set the mark for some of these other Section 2 cases moving forward.
Diana, thank you very much. Apologies to keep everybody a couple minutes over, but I think we're going to have to wrap it there. So I want to thank everybody who tuned in to this really great panel, and of course, thank our excellent panelists for really a very, very interesting discussion. There's obviously still a lot more to come, so please do continue to follow ITIF. We're going to be tracking all these tech cases very closely, and this is certainly one to watch. So thanks, everybody. Have a great day.